morning, everyone. On behalf of the Master Program Online Development, I'm very proud to open this event that will present you the results of a long research project on legal professions. And I'd like to mention that it is an honor to have here some of the most important professors in this area. I'd like to emphasize the presence of Professor David Trubek, who is a Voss-Bascom Professor of Law and former Dean of International Studies, Emeritus of University of Wisconsin-Madison, and Professor David Wilkins. Lester Kissel, Professor of Law, Director of Center of Legal Profession and Vice Dean for Global Initiatives and on Legal Profession at Harvard Law School. And Professor Brian Frank.
Dr. Brian Frank.
Who is a very important professor as well. And also Professor José Garcés and Professor Luciana Gross and Professor Paulo, who is our former student of our program and now is a professor in Pará. And I'd like to mention also that this project embraces several aspects of this that are related to this school, and I'd like to emphasize two of them. Firstly, the empirical study, and secondly, the focus on the global south. So I would say that this is a very important project, and we are very proud to be part of this. So let's start the events. Who is going to start? So Professor David Wilkins, thank you for your presence here.
Thank you so much. Thank you. Thank you. I always have to begin by apologizing. No falo português. Thank you very much for listening to me in English. It is really an enormous pleasure to be here and to present this paper to you, because this whole project really began at FGV. And it began when Dean Arias-Valdo was still the dean here, and we went, do you remember? We met in his office there, which now Oscar sits in proudly, and but to discuss doing a project around the globalization of the legal profession, and in particular here in Brazil as part of a larger project that we call Globalization, Lawyers, and Emerging Economies, or GLEE, as Dave Trubek named it for us. He's the master of acronyms, if you don't know. Ever since then, we've been working with a fantastic team of researchers, many of whom are here today. And this institution has really been just critical to the way in which we think not just about Brazil, but about the whole project together. So we're very grateful to be here. And I'll just say one more thing, because I know many of you are in the graduate program, if I'm correct about that. This project also, from the very beginning, included graduate students, because one of the things that we're most interested in doing is to try to maybe open up some new ways of thinking about research for the new generation of scholars. Because after all, your lives are really the ones that are being remade as we speak by globalization. And your careers are going to be global careers in one way or another, whether you live here in Brazil, or you study in the US or in Europe, or I met somebody who's working on China or Africa. Your careers are global careers. And so it's, I think, particularly appropriate that as we sort of reflect a little bit on what we've learned so far, that we have a dialogue with all of you about this project. So let me say a little bit about what we want to do today and how we're going to do it. But I want to sort of emphasize from the very beginning that we want this to be a conversation. So we have a lot of slides. This is what we do. We have lots of slides. We have lots of data. We've been working on this project now, depends on how one counts, but for many years, and so we have a lot of things to say, but we really want to make sure that we're engaging with the questions that you're interested in. So if you have any questions or comments, feel free to stop us along the way. I take it, Luciana, that there'll be lots of time for discussion afterwards, but please feel free to interrupt as we go along. Oh my goodness, it's like having I just mentioned the legend and the legend appears. It's like that great scene from Annie Hall. Who is it when he's talking about, who is it who shows up?
The Canadian media guy.
Sorry, we're having a senior moment collectively. But in any event, Ari, thank you very much. I just thanked you for giving us the original discussion we had, remember, in your office about this project. And now look what your children have grown up to do. So thank you. I'm going to stand up so that I can both see you and see the slides, because I want to see you because you're the most interesting part. And if I don't see the slides, I will not know what I'm supposed to say. So this paper is our first attempt to try to bring together what we've learned in the projects through the various national studies. So this project to date has really concentrated in kind of 3 places. We really began to do research in India when we were already discussing with Ari and Luciana and Garces and others here in Brazil. We finished a book, which we'll talk about in a second, called The Indian Legal Profession in the Age of Globalization, the Rise of the Corporate Legal Sector and its Impact on Lawyers and Society. We then finished the book on Brazil. Actually, do we have the book? Shouldn't we be holding up the product placement? What, Brian? No, you should all rush out immediately. No, don't worry. There is a book. We have the cover. Okay. Don't go get.
No, you don't want to miss a minute of the talk. It is so riveting.
Yeah, exactly right.
So exciting.
There is a book called cleverly, The Brazilian Legal Profession in the Age of Globalization, the Rise of the Corporate Legal Sector and its Impact on Lawyers and Society. And we're about to finish a book on China, which originally is titled The Chinese Legal Profession in the Age of Globalization. Okay, you get the idea, right? And we've both done a lot of work on the US legal profession, so that's kind of always in the background, and we'll talk about that and its relationship to what we've been studying. And we are in the process of bringing this project to Africa and trying to understand what that would mean and its relations to the other projects. As I said, this is kind of our first opportunity to stop and reflect about what we might have learned across the countries, not just within the countries. And the occasion for that is that we were asked to write a paper in connection with, many of you may know Rick Abel. He's kind of a leading socio-legal scholar in the United States, and something like 30 years ago it must be, maybe more.
No, 30.
Yeah, he wrote a series of books called Lawyers in the Common Law World and Lawyers in the Civil Law World, in which he tried to really, for the first time, do a kind of comparative sociology of legal professions around the world. Rick, because he's a man of almost as much energy as Dave Trubek, has now decided that he's going to revisit that project and is now in the process of compiling and putting together a series of national studies as before around the world, this time to include much more of the emerging economies of the world, which were really not a part of that original volume. And like that original project, there'll be a separate volume which is more expressly comparative and theoretical in nature, which will try to pull together some pieces that try to look across the countries and say, what have we learned about the comparative sociology of the legal profession? And ours is one. And so this paper is sort of our beginning attempt to try to think broadly about what we've learned about the project. Okay, and we call it Re-Gearing the Corporate Legal Ecosystem in a Re-Geared World, Evidence from the Project on Globalization, Lawyers and Emerging Economies.
He likes long titles.
I do. I like long titles. They're not snappy. They don't get on bumper stickers. But hopefully you'll see why it's there. And Brian Fong has been a pivotal part of helping us put together all of these projects. Brian's the research director of the Center on the Legal Profession. He's been intimately involved in all of the research and in the conceptualizing and thinking about this project. So here's where we start with the GLEE project altogether. You know, this started out being a BRICS project. That's the way we thought about it, thinking about the development of legal professions in the BRICS. And we thought about the BRICS because the BRICS have had unprecedented economic development in the last several years. You'll notice actually that we are doing all of the BRICS except for the R so far, because I haven't quite figured out how to do that without getting uranium isotope in my tea. It's a joke. But we start from the idea that they've had unprecedented economic development, and a key factor in that development is what we call the global shift. And by the global shift, we simply mean that in each of the countries we're studying, sometime around the 1990s, a decision was made to open the economy more or less to the global economy. And I want to be very clear about the more or less. No country, certainly not my own, economy is totally open to the global economy, but there was a substantial transformation. So in India, it was going from, in 1991, there was a huge balance of payments crisis, and the government decided to move from a very kind of closed, protected economy, a kind of Indian socialism as it was called at the time, to a more or less market-driven economy. You can look at the series of reforms by Deng Xiaoping, you know, which maybe date back to the 70s, accelerate through the 80s, the handover of Hong Kong, to China's ascension to the WTO. You can think about South Africa moving from, you know, apartheid South Africa to a democratic South Africa, or here in Brazil from the end of the military rule and the beginning of the constitutional regime, okay? So familiar to everybody in this room, and that this produced kind of two big changes in the economy. A big increase in foreign direct investment. In fact, that was the purpose of the move towards more open markets, and the privatization of some, but certainly not all, state-owned assets. And again, you guys, many of you study economic law, economic development, know this story, right? Well, when you get that, suddenly you need a bunch of new law that you never had before, or you never really had to develop before. Like, you need securities law, investment law, trade law, antitrust law, you need or competition law as it's mostly called. You need to kind of elaborate a new kind of ecosystem, legal ecosystem, and you need not only to have your own new laws, but you need to interface with the laws of the global economy, which are, you know, the institutions of global governance, you know, think WTO, IMF, World Bank, but also with national laws of key trading partners and investment partners. And pretty soon, once you get all this new law, you realize you need new lawyers, or at least lawyers with new kinds of skills. Lawyers who know how to operate in these new commercial regimes and interface with the foreign investors who are coming in, with regulators, with institutions of global governance, et cetera. Now, you could get these in two ways, okay? You could import them, or you can grow them on your own. And, you know, importing means the global law firms from the developed legal economies, mostly the US and the UK, some in Europe, were trying to follow their clients into these new marketplaces. But also, in each of the countries that we study, lawyers began to create their own new corporate environment, right? So we study both of these things. We study both the kind of foreign lawyers coming in and the newly emerging corporate legal system, which I'm going to describe in a second, and equally important, the interaction between the two, which then creates various kinds of frictions in the legal ecosystem and more generally. So that's kind of what we try to study, and we have 4 basic research questions. First, how have particularly US models, and I'll say a little bit about why I put the emphasis on US models, of corporate legal practice shaped the development of the new corporate legal ecosystems that have developed in each of the countries we've studied, and from the moment I mean India, Brazil, and China, and what factors have contributed to this process. Second, how has each country's unique situation, its political situation, economic, professional, social environment, how has that shaped these global transplants and the corporate ecosystem generally to produce distinctly indigenous corporate forms? And again, I'll talk a little bit about what I mean by that, and Dave will talk much more about that. Third, how is this new corporate legal sector influencing the rest of the legal profession, right? Like legal education, or professional regulation, or entry into the profession, the demographics of the profession. How has the fact that there is this new part of the legal profession affecting the legal profession more generally? And finally, how is it also not just affecting the legal profession, but helping to transform the political economy of the countries themselves and their growing influence in the world, right? Meaning also reshaping the world sort of economic and political and legal order. All right, those are our 4 big research questions, all right? And as I said, we started in India, Brazil, and China. This is, since we can't hold up the books, we'll hold up the picture of the book. This is the first book on India. This is the second book on China. And this will be the third book on, Brazil, and the third book on China. The best part about these is the covers, which Brian picked, which are these are satellite photos, and they're half day and half night in each country, right? So which is a clever metaphor for something, but we like the pictures. Okay, so in this paper, I want to think about how these corporate ecosystems relate or connect to sort of macro level dynamics in the markets of each country. So we're going to look mostly at that first research question in this paper, which is, are US models diffusing, and if so, how? Okay? And because we like 4s, we have 4 sub-questions under this that we'll talk about in this paper. 1, just to what extent are US models diffusing in each country? That's an empirical research question, and this is a project that's basic commitment is to original empirical research. So all of those books contain multiple empirical research projects on the profession, and we chose that both because we have a strong commitment to empirical research and law and social science methods generally, but also because, frankly, there wasn't any information about most of the questions we were looking at because they hadn't been studied in the countries that we were looking at least not nearly to the extent that they have been studied in places like the United States and increasingly in the UK and in Europe. So, to what extent are US models diffusing? Second, are there significant differences in the process of diffusion among the countries, so between India, Brazil, and China. Are there macro level differences, and I'll try to explain what I mean by that, that help to explain the differences in diffusion? And finally, what are the implications of the interaction between these kind of macro structural level issues and the micro level development of the corporate legal ecosystem, and vice versa, right? How are these things affecting each other? Okay. So Dave is going to talk much more in a moment about the empirical evidence on the first two of these questions, but just to get, so I could get to the sort of framework, the short answer is yes, meaning the models are diffusing, but they're also important variations, and he'll talk more about that. I'm going to concentrate on the second two and try to think a little bit about what's the relationship between these kind of micro level corporate ecosystem and the macro level interaction among the state, the market, and the profession in each country. And here's our thesis, right? That the macro level differences between, in the countries, between the relationship between the state, the market, and the profession help to explain what we see in the micro level variation about the way in which US models have diffused in these various countries. So the basic idea is this. These are what we call the micro level gears. Law firms, which we'll talk about in a second, in-house legal departments, and legal education, which is a little bit of a proxy for the labor market generally. But since law schools have been, for reasons that I will explain, the kind of primary entry point into this new corporate legal sector, that's why we use this as a proxy. The macro level ones are ones that you're all familiar with and you probably study in lots of contexts. What's the relationship between the state, the market, and the profession? And what we're interested in is how do these gears affect these developments in the countries we study? Okay, everybody with me so far? All right. So as a kind of baseline reference point for thinking about these questions, we started with the US. And we started with the US for a couple of reasons. The obvious one is what we know. I've spent more than 30 years studying the development of the US legal profession. But I think it's more than simple parochialism, because the US was the first place to really develop a distinct corporate legal sector of the legal profession. And that's what I want to talk about, that. And that US model, or models, as we'll say, has been a reference point for people thinking about developing sophisticated corporate legal sectors in their own countries. It doesn't mean, and we will say it's not a straightforward diffusion, but it is a reference point. So I want to just talk a little bit about how the US corporate legal sector developed. And it developed around the turn, not of the last century, but the century before last. I often tell my son, yes, I was born in the last century, not 2 centuries. Anyway, go ahead. So around the turn of the 20th century. And it begins with the development of the modern law firm. Now, some of you may be familiar with this, some not, so forgive me if I just say a little bit just to make sure. But in the US, just like most other places in the world, until the early 20th century, there were no law firms, really. Lawyers were essentially solo practitioners or in very small, informal groupings, and they did almost exclusively litigation or in court. That was the definition of being a lawyer, was to be a courtroom advocate. We in the United States have never had the formal separation between, kind of barristers and solicitors like in the UK. But advocacy was the cornerstone of the profession. And of course there were business lawyers, but those business lawyers also represented individuals, and they were organized in much the same way that lawyers who represented people in personal injury cases or divorce cases or real estate closings. There was no kind of separate, distinct corporate part of the legal profession, and there were really no law firms. That began to change, first starting in New York around the turn of the 20th century. And there's a law firm that many of you may have heard of called Cravath, Swaine and Moore, which kind of gets the credit, probably unfairly, for sort of inventing the model of the large law firm that many other people emulated. The reason why you guys are scholars and researchers is because Cravath had a partner named Swaine, who is a frustrated academic, and he wrote the most obsessive biography I think I've ever read. It's something like 700 or 800 pages long. I think it's 2 volumes, actually, each of which is like 600 pages, called The History of the Cravath Firm, in which he meticulously detailed all the brilliant things that Cravath did. And so, of course, now when scholars go back to look at that period, they can pick up that book and suddenly they get all the credit. So if you want to be famous, get someone who's your partner to write a meticulously obsessive biography of you. Ari, I'm looking at you. Okay. And the basic model is one you'll all be familiar with. It was a model of a firm that wasn't based on litigation. In fact, in the early days, they didn't even do litigation. It only did transactional work for corporations or businesses. And that it was intended to be a full-service firm, meaning that it would serve all the needs of these corporate and business clients, which I'm going to explain in a second, were exploding during this period. That it was staffed not by experienced lawyers primarily, but by junior lawyers who were brought in straight from law school, who were trained and developed over a long apprenticeship period at something like 8 to 10 years, even back then in the 1920s. And the best of which were selected to become partners in the firm. And actually, in the traditional system, the others were asked to leave. If you didn't become a partner, you had to leave the firm. It was called up or out, all right? And it was a way of both encouraging healthy competition for people to get these coveted positions, but also to make sure that there was a constant new generation of new people coming in and becoming partners in the firm. Once you became a partner, it was at least formally an egalitarian model, meaning it was a true partnership in which the partners shared, roughly speaking, equally in all of the benefits and risks of the firm, meaning that they shared profits of the firm, if not fully equally by seniority. Footnote, it turns out Cravath himself never believed in that, and he always took huge amounts of money out of the firm. But when Swaine wrote the biography, he left that part out. We had to discover that. Mark Galander discovered that later on. But the formal model was a kind of egalitarian one. Partners ran the firm, meaning they made all the decisions themselves. They voted on the new partners coming in, on expenditures, on anything that was important. It was a kind of egalitarian decision-making model. And that there were no full-time formal leaders of the firm. In other words, the managing partner or the leader of the firm was simply a partner who had been kind of elevated to this position, but who continued to be a partner and to practice law. They were part-time leaders, okay? That was a revolutionary model at the time. But it worked because it was well aligned to 2 critical factors. One was the client market. Because at the time this market is developing, the US is undergoing an explosion in regulation of business enterprises. right? Again, it kind of starts at the turn of the century, but it really rapidly accelerates, particularly after the Depression and into the New Deal. There's tons of new law that corporations have to comply with, or at least interact with, and therefore they need lawyers. And the companies had almost no internal legal expertise, right? They didn't have lawyers who worked inside the company. So these law firms grew up as a way to supply all of the legal expertise that the companies needed as a kind of external service provider. It was almost like an outsourced legal function. And they developed long-term, very close relationships between companies and their outside law firms, in which the outside law firms did pretty much everything from the smallest cases to the biggest cases for their corporate clients. It was also well aligned to the labor market, because at this time, there were many new law schools opening. In fact, legal education was a kind of rarity before the 20th century. You know, Abe Lincoln, our famous president, he didn't go to law school. He was a lawyer. He, quote, read for the law. It was a kind of an apprenticeship model. Beginning with schools you may have heard of, like Harvard and Yale and Columbia, you begin to get a bunch of law schools opening up, which are producing law school graduates who are taught a lot, we hope, how to think like a lawyer, but know nothing about how actually to be a lawyer or practice law. So they were both smart, meaning they'd been pre-qualified and sorted by very elite institutions. It was hard to get into law school. You had to do well, or at least be very well connected. And they desperately needed training and development. And that's what this model, the Cravath model, offered them. They said, come here, work with us. We will pay you a salary, which, by the way, was revolutionary. Actually, law firms small law firms didn't pay salaries. The associates had to pay them for apprenticeship training. They said, no, we'll pay you. You work full-time for us, and we will train and develop you. And if you're lucky, you will become a partner in the firm. And if you don't become a partner in the firm, you'll still be somebody who was trained and developed as a lawyer, okay? So see how the model was well aligned to both the client market and the labor market. And the proof is in the pudding, is a saying we sometimes say, meaning by the 1960s, this model of the large law firm had become kind of the gold standard that people looked at to say this is the kind of highest level of the profession, with the lawyers in those firms not just being leaders in their firms, but being leaders of the entire bar. Many of them went on to be leaders in government. They were hired in civic organizations and nonprofits, in governmental organizations, Secretary of State, you know. They were looked at as the best trained, most prestigious lawyers, and they also happened to earn the highest income. So they were at the top of the profession, and all the law students wanted to go work for one of these organizations, or at least a substantial number. Okay. That was the US. And it didn't exist, this model, almost any place in the world, including in the UK, until the Big Bang. You know, the Big Bang, the deregulation in the 1980s. That's when you have these UK law firms like Freshfields or Linklaters or Clifford Chance. Well, Clifford Chance didn't even exist, so Freshfields, Linklater, Slaughter and May, which were quite small, suddenly grew, and their model was this model. That is, they patterned themselves quite expressly on this kind of Cravathist model. Now, there were lots of variations, and we could talk about more of that in question and answer. That's part of our thesis. It's never a simple process of diffusion, but it began to spread first to the UK, and then people said, well, it's just a common law thing. But then it began to spread to Europe in civil law jurisdictions. And it spread through two ways. One is the UK firms came to Europe, and particularly after 1989, and they began to merge or buy European law firms, and European law firms began to develop as a way of trying to serve this same corporate marketplace. Okay. This is kind of the model. This is why we like to call it gearing. It was a model in which the law firms were dominant. And again, there was very little internal legal expertise, and the law schools were feeding the law firms. And the law firms were kind of at the top of the pyramid. Okay, everybody, that's kind of the micro system. Okay. Then, changes began to happen around in the 1980s. So, the first big change is companies got tired of paying law firms anything they wanted. Law firms used to submit, this is not a joke, one-line bills that said, "for services rendered, please pay me what I tell you to pay me." No detail, no explanation, and companies had to pay it because they needed the help and they had no internal legal expertise. Somebody thought, you know what? It's cheaper to pay wholesale than retail. And so companies began to develop their own internal legal expertise by hiring lawyers to work full-time in the company and to have them do two things. One, to become the chief diagnostician of their legal problems. In other words, to tell them where they had a legal problem and what that problem is. And to be the chief purchasing agent of how they bought legal services, which induced competition for the first time among law firms, right? And that competition, meaning they would actually have law firms bid for work, right? And they would move work around, and they would break up these long-standing cozy relationships that used to exist between the company and their outside law firms. And that began to put pressure on the full-service delivery model because suddenly some areas were much more profitable than others. And companies would only hire you for certain matters other than others. And that began to drive much more attention inside law firms to formal management structures and put pressure on these kind of egalitarian norms among partners, which in turn set off what we now think of as the war for talent. So, in-house legal departments were growing at unprecedented rates, but the supply of lawyers didn't keep up with the growth of law firms and legal departments. And that was particularly true for the lawyers that the law firms wanted to hire from the top law schools, the top graduates from the top law schools. And it put a premium on specialized expertise, which then law firms did something they never used to do before. They started poaching lawyers from other law firms, which had used to been kind of verboten in the old days of gentlemanly no competition. And once you start poaching people, you have to pay them to come, which broke down the kind of lockstep compensation, meaning where everybody was sort of paid the same, into a much more Hobbesian universe of eat what you kill. Meaning, if you have big clients, if you have big billing, you get paid more than other partners. And at the entry level, salaries exploded for young lawyers. So this is just between 2006, by the end of this period, 25% of all law graduates in the US were being hired by large law firms, okay? And salaries in like 15 or 20 years jumped almost 100%, okay? I know, this always gets people's attention when we say now they're being paid $200,000. It's ridiculous. Okay. And in the end, what you have is a kind of fundamental realignment of the market in which general counsels become the primary gear, and you have that law school gear or lateral market gear exerting significant pressure. And it's this that began to be exported, or at least was the dominant idea of the legal market when the legal market, the global shift happens. And it looks sort of like this. In-house legal departments. Remember how law firms were on top? Now in-house legal departments are on top in the US. And this legal education gear is becoming more powerful, squeezing law firms in the middle. That's what the world looked like when the global shift happens and things begin to move towards India, Brazil, and China. And I will now move to Dave Trubek.
So it's important to understand that we're dealing with this very complicated interaction. Things are happening in the United States at one speed, and things are happening in Brazil, India, and China at a different speed, and it's important to keep that in mind as we go through this. It is true that at the time that the global shift occurred, and we'll go into that, in Brazil, India, and China, the Cravathist, neo-Cravathist model with the general counsel gear, I love the gears, right? Being the big gear, right? You get the big gear and then the middle-sized gear and the little tiny gear, but anyway, the big gear was, but this is not exactly how it happened and developed at that time in the other countries. This is the important thing. So there's a lag in what happens in Brazil, India, and China, a lag. Although there is diffusion, it is not an immediate diffusion of this model. It's actually the earlier model that first diffused. Because this model, while looking back on it now, it all seems very clear, and we can say, hey, this year, you know, blah, blah, blah. Actually, it wasn't so clear at the time, even to the people in the middle of it. And so the older model was still in people's minds and had you know, more solidity, let's say. And it also, as we will see, fit the ecosystem at the time of the emerging economies. So keep this in mind as we go through this. So David has sort of suggested, and I'll just go quickly through, the changes in economic policy that made up the global shift, and then some of the legal changes. Again, you've already heard this, and you all know it because many of you lived through it, or at least are now studying it. So tariffs were reduced, state-owned enterprises were privatized. One of the studies that I think is, you know, very important in the book about Brazil is the study of corporate lawyers and the privatization of the telecoms industry in Brazil. This is a very important article because I was one of the authors of it. But actually, I'm joking, it's important because it shows the granular micro data about how corporate lawyers dealt with this and helped shape the privatization process, and then how what they did affected state policy. And unfortunately, that latter point is not as clear in the chapter in the book as it is in the subsequent article published in the journal called Law and Social Inquiry, in which we show that what the corporate lawyers did in creating a regulatory structure for telecoms companies that had been privatized, how that influenced the kind of development policy that occurred under Lula and Dilma when the state tried to basically retake the sector for state policy. So that's a very interesting development. Regulation was reduced or not reduced, because a lot of what happened was regulation had to be introduced. So when you privatize a sector like telecoms, then you had to create regulation of these now private firms, which wasn't necessary before because they were controlled by the state. You wanted to attract foreign investment. you wanted to stimulate a domestic capital market. There he is, the man who stimulated the domestic capital market all by himself.
It was a Marshall McLuhan moment.
It was Marshall McLuhan, that's what it was. Good for you. There was an effort to build national champions and to encourage investment overseas. And this is happening in all three countries to one degree or another. Obviously, you know, there are great differences. China privatized a much smaller part of the economy than, say, Brazil did, and so on and so forth. But of course, as David has said, new legal fields emerged as a reflection of these policies. And of course, there's WTO and there's bilateral investment treaties. I mentioned the regulation of privatized sectors, competition, securities law, regulation of FDA, and learning how to handle mergers of acquisitions that are transnational, because a lot of what's happening is foreign companies coming in and buying up local companies in these countries. So, and that, of course, meant that the lawyers had to learn to deal with foreign clients. There were always lawyers, say, in Brazil, who knew how to deal with foreign clients. I announced yesterday that I was the oldest living client of the Pinheiro Neto firm because I actually was a client of that firm in 1965 when I was the lawyer for the U.S. Embassy, and we retained the firm to represent the embassy in some negotiations that we were having with Brazilian companies. And the point is that this was a firm that had early learned how to deal with foreign clients, and there weren't a lot of them in Brazil in the 60s. That was a very important thing that had to happen after global shift, because the number and scale of foreign participation grew dramatically. So let's look at Cravathism. Now remember, Cravathism is that original model of the full-service law firm, which basically is providing most of the legal advice to corporations with relatively weak general counsel's offices in the corporations. Therefore, the firms are the controlling gear in the gear metaphor. So in all three jurisdictions, Cravath-style firms grew up beginning in the early 90s. Now, as we'll see when we look at a little data, there were Cravathist firms or proto-Cravathist firms, again, Pinheiro Neto being an example that goes back to the 40s in Brazil, and by 1965, when I was a client of the firm, I believe there were 30 lawyers, and it was organized along Cravathist lines, with entry-level lawyers coming in largely out of school and being trained up within the firm and sent often to New York to do sort of internships in some of the partner firms that they had built alliances with. So this was, and there are similar things in the other countries. And as I said, this fit very well with the ecosystem of the United States in the period 1960 to 1980s. That is the period preceding this period in the United States. So in a way, they were going back to a time, a model that was already beginning to unravel a little as the neo-Cravathist epoch occurs in the North. But China was different. And if you want to take away one sort of bullet point or, slogan from this whole lecture, which will go on for hours and hours and hours, you want to just compress it to one line: China is different. China is different, and you're going to see this over and over again as we go through the details. So the first is that China actively made the creation of a corporate legal sector part of its industrial policy, just like the creation of a high-tech industry, of outsourcing, of this, that, and the other thing. Chinese policy, government policy, recognized the importance of a corporate legal sector as they were trying to build their relationships with the world. So relative to the other two countries, Chinese government had fewer regulatory restrictions on both the domestic and the foreign firms, and allowing Chinese lawyers to work for global firms. There were restrictions, there's no question about it, but it was looser, it wasn't that well enforced, and also China actually encouraged the creation of large law firms. And indeed made it clear that, that this was an important policy. And so compared to the other two countries, early on in this first stage, you see larger and more differentiated large law firm sector in China than the other two countries. So that's the first China is different factor. Now, in the in-house counsel, the other part of the other gear, as it were, the in-house revolution that we've described happening in the United States and then spreading to Europe doesn't happen in the three emerging economies that we study. It doesn't happen at this time. This is what we call phase one, 1990 to 2000. Okay, so there are a number of reasons. The first is that a lot of the investment is coming from foreign multinational corporations. They have their own legal offices, and maybe they'll have a small little operation, but they run their legal function out of the home office. They're not going to set up a big operation in these countries until they have some sense that this is a long-term major investment. It's too early for that. And the companies, there was no tradition of having strong in-house counsel in any of these countries in the corporations, whether they were public or considered, whether they were private companies, privatized companies, or SOEs, state-owned enterprises. And legal education also very slow to respond. Of course, there's a big demand for skills, but the law schools in all three countries are slow to respond. So let's look at the history of the these firms. So these are this shows when the firms that are ranked in the top 40 Indian law firms were founded by years. And so if you look, this is the early group, but most of the firms are founded after the global shift. So something like what?
Right around 1990.
No, I mean, what percentage? It looks like I should have figured this out, but most of them, about 85%. It's about 85%. So in India, the existing firms, of course, there are lots of existing firms that you could put on this chart, but they aren't ranked top 40 now. So this is to understand this chart. You have to understand. Only the top ranked firms as of, say, 2 years ago or 3 years ago, I don't remember the year.
2015, I think, or 16.
Well, whatever. And anyway, those are the firms that get put on this chart. Of course, there are many more firms that were founded in these earlier years, but they didn't make the top 40. And the firms that have made the top 40 are almost all formed afterwards. So this is a contrast to Brazil, as you will see, where there's more firms survived this transition. So this is the data formation of corporate firms in Brazil by decade. And you can see, again, that this is when the great majority of firms that we code it as corporate firms, were founded. Again, this is similar in the sense that it's the global shift that creates this great demand for corporate law. But in Brazil, more of the firms that are highly ranked were in existence. There were more, a higher percentage of firms were in existence before the 1990 than in India. This is chart. I hate this chart because I don't understand it. Right? They stuck it in here and they told me I had to talk about it. But this is all Brian's fault. But he's so smart that he can understand this chart. But
It has a simple punchline.
yeah, it has a simple punchline, which is, look when most of the major firms were founded. Oh, 1989, 1990 to 1999. Oh, they're almost all in that period. Oh, gosh, that's what it means.
Yes.
So don't worry about all these lines going up here. It's too confusing, right?
Yes.
Okay. So what's the difference between Brazil, India, and China in this phase one? Remember, what we've done is divide the history of the emerging economies into two phases. 1990, 2000, 2000 to say 2015, more or less, when our data pretty much goes back there. Okay, so we saw diffusion. David's already told you that that there's diffusion, and they're U.S. models more or less. The law firm sector is the driving gear. We've already said this. Now, the firm origins. Okay, there were lots of what are called British Raj firms that were active. These were British firms set up. Don't forget, India was ruled by Britain until 1947, right? It was wasn't a colony. What was it exactly?
The jewel in the crown.
What was the jewel in the crown? It was,
It was a protectorate, I think.
No, it wasn't a protectorate.
No.
It was part of the empire.
Yeah.
I don't know exactly what the classification. I mean, I've read 40 books about this, and I can't tell you. But anyway, the British Raj was the governing system of India from the early 1800s until 1947, and it was part of the British Empire. And of course, they had law firms, and there were lots and lots of British business in India, and those companies continued after independence, which was in 1947. But these firms, which continued under what David described as Indian socialism, were very much old-style British law firms, and they did not adapt to the new world post-global shift, post-1990. And new firms had to be formed. So you can see we saw the numbers about how all the firms that are now, almost all the firms that are now important in Brazil, in India, came into being after 1990. And none, I think, or almost none of the British Raj firms, which were staffed by British lawyers, largely originally, and then they brought in Indians. Very few, if any, I'm not sure.
They certainly didn't transition into being the most important. They were left behind,
Yeah.
even though they had a huge first mover advantage.
Right. Okay. So I love this proto-Cravathis, right? Would Pinheiro Neto be happy to know that he was proto-Cravathis?
I think the answer is yes.
Yeah, probably. But he certainly was.
Yeah.
Now, in China, it was a bit different, because in China, they didn't have law firms, right? Because they were all eliminated. There were law firms in China go back into the 19th century, but when Mao came in, they decided lawyers were superfluous, and so they got rid of all the lawyers, right?
Let's kill all the lawyers.
Huh?
Yes.
Let's kill all the
Let's kill all the lawyers, right?
Or at least send them to re-education camps.
So in China, unlike in Brazil and India, there were no law firms. They had to be created, and as we've suggested, the state played a role. And they encouraged these firms, and David always brings this out, and I think it's wonderful. that they, one of the firms that was created in that period, in the post 1990 period, is called King and Wood. Now, there is actually nobody in this firm named King and nobody named Wood. But two Chinamen, whose probably name was Lu and whatever, decided that they'd attract foreign clients better if they had names like King and Wood. Yeah. And the government thought that was a great idea. And so there it is. And now it's merged with an Australian firm, so it's King, Wood, and Mallison. Mallison? Right. Yeah. So there you go, right? I mean, so this, again, nobody created, Smith and Barney in Brazil, right? We still had Pinheiro Neto and Matos Filho and all these Brazilian names. That's a Chinese difference. Whether it's a good one or not, I don't know. But you can see the Chinese aiming much more directly to grab this market. Now, there are other differences that I'm going to go very quickly through. How do social networks influence the evolution of the firms, and how does that affect the differences both between the countries, but also between all three of the countries, and the so-called Cravathist model that they were, to some degree influenced by. So in India, you see religion, class, caste, they're all important, and you find that certain firms work with certain castes, with certain regions, and there are problems within the firms where issues of caste and religion and class affect promotion and governance in ways that you didn't see in the other countries as much. But in Brazil, the recruitment is largely from an elite group who are also the graduates of the elite schools, and so you still have that factor. And in China, we don't know, but we think that party ties may have had an influence in who became corporate lawyers in that period, but we don't know that for sure. So, okay, so what's the difference between how the countries regulated the firms? India has extremely strong restrictions on what firms can do, particularly restrictions on the number of partners in a firm, so you can't have more than 20 partners in a firm. He knows all this, right? So I have to always look over there to be sure, because, so if you want to have more than 20 partners, you have to create multiple law firms and then link them together. So there's always a gimmick, right? The lawyers always know a jeito, right? So the jeito in this area is, and you can't have more than 20 partners. So you create 6 law firms, and they each have 20 partners, and then they have some deal among themselves, and they actually operate like one entity. But they're okay. But that takes time, and it does affect actually governance, and it changes things. You can't have websites. Indian law firms can't have websites. And there are other restrictions on marketing and branding that are very, very strict. Brazil has somewhat similar, but nowhere near like the Indian. And China is pushing the countries to be, pushing the firms to act in commercial ways, to be entrepreneurial, to have marketing, to do all the things that firms do now in Europe and the United States. The Chinese not only allow it, they encourage it. So again, remember, China's different. Okay, also foreign firms. In India, technically, foreign firms cannot operate in India, can't come near the place. You cannot set up a foreign law firm in India. You can fly in, stay in the Taj Hotel, have dinner with your client, and chat a little bit, but you better not open an office. So again, how do you do that? Well, you set up an office in Singapore, you set up an office in London, you hire lots of Indian lawyers who work in Singapore and London, and they fly in and they operate as if they were in India, right? So again, in the modern world, it's pretty hard to actually make such restrictions work. But they cause costs, and they cause certain differences in variation. So I'm not going to go through this. Brazil also places restrictions, but less than India. There is some cooperation agreements allowed. This is a very complicated thing. It's been going through recent changes. I am not up on the most recent development. You probably know more about exactly where we stand. But basically, there's been a tug of war between the large domestic firms and the foreign firms about how foreign firms and domestic firms can relate to one another, and how foreign firms, what's the scope of activity of the foreign firms in the country. Again, nowhere near like the Indian, but still some restrictions. And China, which decided that in order to attract foreign direct investment, they want to attract foreign direct law firms, foreign law firms, they have encouraged it. So like I don't know the exact numbers as of now, but as of the time that we were putting all the data together a couple of years ago, I think there were 32 foreign law firms in Brazil operating in very small, restricted ways, and 250 or more in China. So that gives you some idea of the China is different story on foreign law firms. Okay, now, ladies and gentlemen, we now move to a new era, a new exciting era, the neo-Cravathist era. This is neo-Cravastim era. I don't know. Something wrong here, but anyway. So, everybody knows about this, right? You remember the day when neo-Cravathism started in Brazil and India. Do you all remember that day? It was a lovely, warm, May day. It was just beautiful. And all of a sudden, neo-Cravathism starts. No, I'm joking. So, all right, now this in-house counsel movement that you have learned about in the U.S. context suddenly begins to take hold. And last night, a couple of you were there at the launch of the book at Pinheiro Neto in their modest little offices on Rua Hungria. And they confirmed to a T that this in-house counsel revolution has hit Brazil seriously. And the changes that were just described in the American scene have now happened in Brazil. And we'll see how that plays out in the other countries. Now, our data suggests that the foreign multinational corporations operating in the three countries were the spearhead of this change. That is to say, that they brought with them what was already there in the United States or Europe, and that influenced the local markets, and of course became part of the local ecosystem to the extent that foreign firms were important, and that varied, of course, with Brazil and China, foreign firms being more important, relatively speaking, than they were in India. So the general counsels in all three countries, to one degree or another, at different speeds, general counsels moved to become chief diagnostician and purchasing agent, and they start entering the senior leadership of the firms. This is a very important part of neo-Cravathism that is very important to understand. It's a shift because even, let's say, in the 1960s and 70s and 80s, 60s and 70s in the United States, there were general counsel in these firms in the United States and also in Europe, and they did quite a bit of work, but they weren't the tacticians and the diagnosticians and the strategists for the firms. That was the job of the senior counsel of the outside firm. and therefore they were not part of the senior leadership of the corporation. And this is probably the most important part, the two most important parts of this so-called in-house revolution, is the move into this, into the leadership of the firm, replacing the outside counsel, who used to be sort of like a regular, almost regular member of the senior leadership, obviously in an informal way, in the making of strategic decisions, risk assessment, the big corporate decisions. The general counsel of the firm is now becoming, in the emerging economies, as they had become already in other parts of the world, senior leadership. So that, plus their control over the budget and the hiring of the outside firms, is what changes the gearing in the neo-Cravathist era, and that is happening. And again, this is what is a disruptive force. They suddenly are hiring lawyers for particular skills, not firms. They're looking for the best lawyer, and if that isn't in the firm that used to handle some of their business, they're going to go to another firm. And again, with the increasing need for specialization, then you get competition among the firms, and you get the rise in all three countries, to one degree or another, of boutique firms that just do one specialization or two specializations, because in that ecosystem, you don't have to have a full-service firm, because the general counsel's office is the full service, is where the full service is, and then they take the pieces that they feel they can handle, and they shop it out on a transactional basis to firms, but not because of the firm so much, but because there's a specialist in that firm who they want for that particular task. Now, our data shows, and David can answer the more detailed questions because he's the one who's done the detailed data on this, that this has happened much faster in Brazil than in the other two countries. So this is an area where Brazil is really the leader, and boy, that was clear as crystal clear in the discussion last night between the general counsel of Amazon and the managing partner of Pinheiro about how their roles have changed over the last 10 or 15 years. It was very, I mean, it was like, if we could only tape it, it would be better than this entire presentation because it was so vivid. All right, so the law firms, of course, begin to change. Well, it's not like the law firms are being replaced. And so demand for law firms grows and the firms grow. It's just that their role begins to change. And this happened in all three countries, that the firms seek to try to move up the value chain, to do more and more of the high-end work. But then the demand for specialization causes a disruption of the internal labor market, and lateral hiring starts in the emerging economies. And you get these peel-offs, is what the India study caused peel-offs, people who leave the big firms and set up specialized boutiques because they can compete for the work that's being parceled out by the general counsels for highly specialized activity, so that it begins to sort of break up and you begin to get a more diverse kind of ecology of corporate firms, rather than just having a lot of big full-service Cravathist firms. Oh, legal education slowly responds. This is really news, I'm sure, to everybody. This is a really exciting headline here. Legal education slowly responds. Oh, God, legal education's always slowly responding. I don't know why this is. So all of a sudden, the sector's growing, and there's a demand for much more specialized knowledge. And this puts pressure on the education sector in all three countries. So actually, a few U.S. law-style law schools or global-style law schools emerge based on global models. In India, there's one called Jindal. In China, there's one called the Peking School of Transnational Law. I don't know why they kept the old Peking word. I guess that's
But
because
does Peking University?
Peking University never changed its
Never
name
changed
to
its name.
Beijing. So
Right.
I guess that's the source of that. So, and Peking University was the most elite university traditionally in China. And then there's this place in Sao Paulo that you've probably heard of. And some existing law schools in these countries begin to internationalize. This happens in India and, of course, in China. But the demand is not, even you know, the most responsive sector, which is clearly, oh, here we go, China is the most responsive sector, is insufficient, and therefore a lot of workarounds are required. So here's a few little things about the difference between Brazil and India in the general counsel world. So they're pretty much the same in these three major dimensions: managing the legal department staff, well, I don't know what else they would do. Managing outside law firms, they all do that, and managing outside, hiring and managing, sorry. Okay, but then we get some real differences, where the Brazilian general counsels are more important in the companies than India, the Indian general counsels, which is a sign that the general counsel revolution has moved to Brazil more fully than it has in India. But it seems that the process is going on, and one can predict a continuation of this in India. And in Brazil, it's, you know, it's still not ubiquitous, but it's developing. Okay. So let's look at some variations in phase two. Remember phase two. So there's competition, and the pressure from the general counsels, again, not quite as strong as in Brazil, but substantial. So in India, the Cravathis firms abandon the internal labor market and turn to lateral hiring. Some of the large firms are limited because they stay with castes and ascribe other forms of ascribed status, which makes it harder for them to grow. And it also means that some talented lawyers are sort of decide to move because the promotional possibilities in these firms are controlled by families, by caste. But the new market makes it possible for them to set up boutiques. I've already said that. The government continues to strictly restrict, the government and the bar, to strictly restrict marketing and sort of commercial activities. The foreign firms find ways to operate through the mechanisms that I suggested. There's a demand for better trained lawyers, so there's a couple of new law schools that adopt global standards. But the most interesting part of the India story is that before this period, but not much before, just about the same time, India had created national law schools. These are freestanding law schools. They're not parts of universities. They're freestanding law schools. And they were set up, I think, originally with the idea that India demanded better lawyers for the public service. And this came out of the older tradition, pre-global shift tradition. But they were set up, with substantial resources, sort of very elite model following the model of their engineering institutions, right? The engineering, very famous Indian engineering schools are famous, and they're world class. So this was kind of something that they had in mind, but they were going to train lawyers for the government. But of course, as global shift occurred and all this market demand occurs, the students think, why should I go work in the Bureau of whatever and make, you know, equivalent $50,000 a year, $40,000 a year, when I can go work for one of these booming corporate firms that have big offices and stuff like that. So the students pressure the schools to become more oriented toward global legal practice. The pressures come from the students. These schools have no system to connect their students to the labor market, that is, to bring the firms and the students together, as, say, an American law school has a whole, you know, office that does this. Right? So the students create their own system where the students manage an operation to bring the students and the firms together. It has nothing to do with at least initially, I don't know, maybe they've been picked up.
Still does.
It's still run just by the students. And so the pressure of the students also, you know, affects the schools, and they gradually, but often, in some cases, grudgingly, try to move toward more corporate, global, internationalized legal education. They have the base of relatively good budgets and salaries and full-time faculty and, you know, tradition of scholarship, which gives them an edge, but they have also the tradition of being set up for public service, and so there's resistance within some of the schools, at least, to this kind of globalization. Brazil, I've already said that the GCs are pressuring the Cravath's firms, abandon the internal labor market. We've gone over a lot of this. The domestic firms are, in order to succeed in this competitive economy, the domestic firms want to do more marketing and branding, and they push against the regulatory limits and find ways to get around some of the restrictions from the OAB. There are efforts to create formal alliances. There's restrictions placed by the bar, and so a lot of formal relationships become difficult, but ad hoc and informal relations continue because it's necessary to have these relations in order to provide seamless service on legal problems that are transnational, multi-jurisdictional, and involve, you know, often the legal systems of three or even more countries. You can't divide it up into little packages and say, okay, over here we got the Brazil law guy, and here we got the French law guy, and here we got the New York law guy. Here's the guy who understands, you know, WTO law, and they're just going to each send little memos to somebody, to somebody. That's not the way you do legal problem solving. You have to have everybody together on a team, pulling in all the different relevant things. So in the real world, people have to find ways to make this happen, despite all the restrictions and the protectionism and the regulations. And so this is what's going on now. You know, you can't. It's not so visible, so we can't really report all the details of this based on, you know, formal observation. And the demand for lawyers grows. Oh, one private law school adopts global standards. I have no idea what that is. Public universities resist significant change. Wow. Boy, do they. That's all I have to say. And then there are workarounds, you know, LLMs, internal training, continuing legal education. Listen, Emerson had to leave because he probably has to go train 400 people. But the demand for continuing legal education here in Brazil is a function of many things, but it's a function in part of the failings of the law schools, with very few exceptions, to give lawyers what they need to operate in this new world. So, you know, in a way, FGV is benefiting from the failure of the Brazilian legal system to be up to date, even on the most practical Brazilian law things, let alone all this more cosmopolitan stuff. And here we come to China. Okay. So we've got all these kind of pressures going on, the same sort of pressures we've been talking about. I just mentioned you.
Yes.
I know.
He was trying to make you leave, but thank you, you're still here.
So, okay, so in China, they invent new kinds of legal forms. They don't just take the Cravathis model and then adjust it to the local reality. They invent completely new forms, like a system where there is a law firm, but actually it's just basically a system to rent space out to lawyers who then are in some kind of cooperative communication system, but they are actually not formally part of a firm, if I understand. Again, this is one of David's areas of expertise. And here the Chinese firms started by just doing the low end of the transactions with the foreign firms. Don't forget, the foreign firms have a substantial presence in China, a very substantial presence in China compared, say, to Brazil. So a lot of the Chinese firms, even the ones that are called King and Wood, or I don't know, Chumley and Windsor, right? Chumley and Windsor. That's a firm. That's a name they could have used. But the domestic firms begin to say, okay, wait a minute, we can do this work, and so they bring in foreign firm lawyers who've been working in China, and they move up the value chain, and this is really, I think, one of the most interesting things. The government supports and encourages Chinese firms to merge with foreign firms to become global players. Some of these have worked and some of these have not worked. There are some problems allying with Chinese firms, but there's a clear government policy and strategy to do this. Again, China's different. And as the domestic sector grows, there's a challenge to the foreign firms who begin to lose market share to the big Chinese domestic firms. Again, developments in the corporate core created demand for more lawyers. The government invests heavily in the internationalization of universities. This is not necessarily a lawyer-oriented, it's a university-oriented policy. We want our universities to be global universities, and they poured money into the universities, encouraging them to build alliances, to send their faculty abroad for advanced degrees, to attract foreign students, to do all the things that internationalization of a university involves. And the law schools are able to take advantage of this huge amount of resources, and the schools that do that attract the best students. So there's a kind of dynamic here where internationalization builds on internationalization, then they get the best students, and then they're able to get more resources. And so Chinese universities and Chinese law schools are much more internationalized and globalized than the other two countries. And this is, again, the result of government policy, among other things. So they're both new law schools that are formed and by some of the science and technology universities, and some of the old elite schools like Peking and Renmin. They're retooled, and then as I say. So now that you know all this incredible factual detail, Dr. Wilkins will explain why it all happened.
All right. We're coming to the end, we promise. But, listen, there are 3 books, there are thousands of pages and hundreds of studies. But I hope you've got at least a sense, right, of what we're trying to understand. So remember the 4 questions I began with, right? To what extent are the U.S. models diffusing? Are there significant differences across the jurisdiction? Are there macro level structural differences that help to explain the micro level differences? Oh, I'm supposed to? Oh, sorry. So, is it on? Yeah. Okay. Quickly recapping, I said was we're going to return to the 4 basic questions we started with, which are, to what extent are U.S. models diffusing? Are there significant differences across the jurisdiction? Are there macro-level structural differences that help to explain these differences among the 3 countries? And what are the implications for the relationship between the macro level and the micro level, okay? Dave has just made clear that the answer to the first 2 questions is yes, that the models are diffusing, but that there are really important differences across all 3 countries, particularly, as Dave has emphasized, between China and, on the one hand, and India and Brazil on the other. So I'm going to try to concentrate on these second 2 questions to try to look at the relationship between the macro level issues and the micro level issues to see if they help to explain some of these differences. And again, the thesis is that macro level differences help to explain both the diffusion and the variation, and that the interaction between the macro and micro will play an increasingly important role as these markets become more globalized. So in the very last slide, I'll try to say something about the future moving forward. So if we start back with the US, right, how does the kind of ecosystem that we saw develop between Cravathism to neo-Cravathism, how is that related to these macro level differences between, about the relationship between the state, the market, and the profession? So the U.S. lawyers have always thought of themselves and pride themselves on being an independent profession. And by independent, they mean independent from both the state, right, from government, and also from the market. But the corporate legal profession itself is actually the creation of the market. That's what I tried to explain way back, if you can remember in the beginning, about why we got corporate law firms to begin with. We had an explosion in legal regulation. There was a market response, the creation of these corporate law firms, which then fed off the new market for legal education that was happening around the same time. So yes, the state was responsible for passing all of these various laws, but the state basically has stayed out of how the demand for corporate legal services in the United States is to be fulfilled, right? The government hasn't, at least to date, intervened very much. And while the legal profession in the United States is strong, it's never had the kind of control that I'm going to argue you see in India and Brazil. That is, the profession has basically had a regulatory system open enough to allow for the fulfillment of the demand that was created by these new laws and the creation of new forms like the large law firm that didn't exist before. Right? So one way to think about this is the Cravath model, which we think of as the established U.S. model, when it was developing in the 1930s and 40s and 50s, was actually quite, certainly in the 1930s and 40s, was quite unpopular. There's actually a very interesting, everybody remember Life magazine? Actually, you may not. Actually, Ari remembers. Okay, you and I remember. Life magazine, back when magazines were really important. It was kind of a big, glossy tabloid. It was the most important magazine in the United States. And they did a profile on Paul Cravath, the founder of Cravath. I'm sure he thought this was going to be great. It was extremely unflattering. And it basically said that Cravath was destroying the legal profession by creating, quote, law factories, which were destroying the kind of ideal of the independent professional, which had been the ideal before. You know, the solo practitioner, the English barrister model, non-commercial, public-oriented, and turning out these automatons who would work on these small pieces of legal matters for endless hours as part of a big organization. That was the critique. And the organized, much of the bar held that critique because they weren't actually in these law firms. They were mostly, the bar was controlled by traditional solo and small firm practitioners. But they were unable to stop the kind of advancement of the Cravathis firm because there was such a strong market demand for it, and these firms were allied with powerful market actors, i.e. big corporations, and by the 1960s you had a complete flip in which the Cravath firm was the most important, most prestigious part of the market. So see what I'm saying? The profession's important, but it's not able to stop the kind of market dynamics that ultimately drive the shape of the ecosystem, right? And when you got the in-house counsel movement, they basically used the market lever, i.e. their power and their control over the large clients, which, as Dave said, the most important thing is not just that they're lawyers, but they sit on the senior executive committees. Their offices literally are right down from the CEOs, and they therefore controlled the purse strings, which then drove the disintegration of the Cravathis model into the neo-Cravathis model and pushed the labor market through lateral hiring and increased demand for specialization. So, if you think of the macro gears, market, legal profession, and state, micro gears, this is neo-Cravathism, right? In-house legal departments, law firms, and legal education. In the US, it's the market gear that's dominant. And it had pushed the move from Cravathism, when these people were on top, to neo-Cravathism. Okay? All right. Now think about India and Brazil, and the story that Dave brilliantly told about that. So we know India, Brazil, and China have all rejected key elements of the Washington Consensus in favor of some form of a development, of a strong developmental state, different in different places, but all of them have made that turn, right? And Dave Trubek and others in this room have really been responsible for telling that story. But in India and Brazil, the state hasn't played a key role in the development of the legal profession itself. As Dave kind of jokingly said, they didn't say to Ari, go start a law firm. Right? Ari started the law firm, right? They haven't invested in legal education, the globalization of education in the same way, right? Instead, both countries have allowed the legal profession itself, the organized bar, to be very powerful in how the corporate ecosystem develops. It's easiest to see this in India, where the legal profession is barred foreign firms. And even though there are lots of workarounds, the fly-in, fly-out, stay at the Taj, the fact of the matter is, still to this day, you cannot set up a foreign law firm in India. I mean, it's sort of amazing, right? In the kind of global age that is still the case. And just to show you how powerful the profession is, the Modi government, which came in a few years ago, expressly made changing this a policy priority. I would talk to government officials, they made public statements, they put somebody in charge of it. They told me, don't worry, this is going to change because we want India to be open for business. We want it to be fully integrated into the global economy. We don't think our legal services industry needs protection anymore. And then last year, the Supreme Court of India reaffirmed the bar on foreign law firms coming into India. The Supreme Court is staffed by judges who are all former members of the legal profession, very close ties between the top lawyers and the judges. Basically, the profession struck back, as Spielberg might say. In Brazil, Abe has been less successful. You know, they haven't barred foreign firms, although I will say is not for lack of effort. But, you know, they've been pushing hard to maintain control over legal practice. There's been movement about commercial practices, but, you know, listen, you know better than I do that the bar still is quite powerful about, as a regulator, about the commercial legal profession today. So again, if you think of the story that we told, in which there's been less movement towards neo-Cravathism in India and Brazil, it's there, but it's been less movement, and it's in part because the legal profession doesn't want it. And the legal profession still remains quite powerful, and the lawyers who became powerful in the global shift exert still a tremendous amount of pressure. And this is particularly true in India, where the story is the most extreme. Okay, China. China is different. And in China, basically the state controls everything, okay? One way or another, under one name or another. I have a colleague who some of you know named Mark Wu, who's written a terrific piece called China Inc., in which it, you know, he charts the way in which all of the interlocking mechanisms of the government, even in so-called private industry, even in regulation in the courts, China Inc. continues to exert very strong control, notwithstanding the WTO and lots of other people trying to push back, okay? And there was no legal profession until the government created it again after the opening of the law schools. In fact, one of the people, when we did our work in China, we did a big presentation in China, one of the people who talked was a member of this famous class of, what is it called, class of 75? Yeah, I think the law schools opened in 75, so maybe they're the class of 1979. That's the beginning of the legal profession in China. And basically, after the Chinese government rebuilt it, they put it under the control of the government. So lawyers are regulated by the Ministry of Justice, or the state-owned asset regulatory commission sets the standard, okay? And as Dave demonstrated, unlike the state in Brazil and India, the state in China has seen the development of a corporate legal ecosystem as an integral part of its developmental strategy. And it's therefore pushed for the development of that ecosystem in all kinds of ways by facilitating new corporate forms. And here's, I think, the key part, knowledge transfer by global players. They wanted the foreign firms in so they could learn from the foreign firms. They allowed the foreign firms to hire Chinese lawyers, knowing they weren't supposed to practice Chinese law. They were only supposed to, quote, opine on the Chinese legal environment. What's exactly the difference between that and practicing law? Nobody quite knows, but it allowed the government to have this kind of loose boundary. They pretty much knew that the foreign firms were not going to make these Chinese lawyers partners, which meant there was a huge training ground in which the foreign firms would train the Chinese lawyers, and then the Chinese lawyers would go back out and work in the Chinese law firms, taking with them all the knowledge that they had. They also sponsor Chinese students for LLMs. Now, increasingly, they're going for full 3-year JD degrees. They're not just going to the US, they're going to the UK, they're going to Australia. So there's a huge knowledge transfer that the government feels in the end benefits China by giving it access to this kind of global standard lawyering. And we know China picks national champions. So King & Wood, the firm we always love to tease about, the fact of the matter is the reason why King & Wood has become very powerful is that the government basically encourages state-owned enterprises to hire King & Wood for not just their domestic work, but also increasingly for their outbound work. And that's one of the things we're beginning to look at, right? So just like China picks solar manufacturers and Geely car company, they pick national champions in the corporate legal space. And their goal is to protect state-owned assets. And that's why they are pushing the upgrading of the in-house counsel function inside state-owned enterprises, because they had a number of disastrous occurrences in which state-owned enterprises went to and bought companies in the US or began operating in the US or the UK or Europe, and they were operating as if they were operating back in China, which means they had 2 sets of books and everything was guangxi, and and then they got busted by the SEC for accounting fraud and had to pay tens of millions of dollars, which of course comes out of the state-owned budget. So the state-owned assets, the government realizes that having a functioning in-house legal department that protects against legal risk is something that's very important for the government as well, okay? And as Dave said, they want to ensure an adequate supply of globally trained lawyers, both from the law schools and from hiring from firms. And the part that Dave said, but I want to emphasize, Chinese law firms now employ a bunch of non-Chinese lawyers who are coming out of global firms of people who've been in China, are now being made partner inside Chinese law firms. And the merger with the Malice and Stevens and Jenks, which was the top law firm in Australia, was just a massive importation of expertise and knowledge transfer encouraged by the Chinese government. So, if you've got neo-Cravathism here, in which now in-house legal departments, law firms, and legal education are working in concert, the state is driving this change. And this helps to explain why this looks quite different than in the other two. All right, last slide. I promise, last slide. No, actually, there's one more, but it's just a picture. So where's this all going, okay? It was very interesting. For those of you who were at Pinheiro yesterday, most of the discussion was shockingly not about our empirical evidence in the book, which I'm sure they had read very carefully, but instead was what's happening to the corporate legal market today. And in particular, what are the big drivers of change, and how's that likely to affect Brazil? So we know since the global financial crisis, since 2008, that corporate legal markets around the world are increasingly undergoing 2 significant transformations, both of which were talked about yesterday. One, even more rapid global integration. Now, there's now pushback and protectionism and all of that, but at the business level, this is why whatever my crazy president, I'm not going to talk about your elections, I'll just talk about my own. Whatever Trump says he's going to draw the borders and all of that, you see who's totally against that? The business community. Because they realize they live in a world of integrated global markets, and that's the only way they're going to continue to profit and succeed. And they're taking their lawyers with them. That's what they always do, right? And particularly in a market-led society like the US. And the second thing is increasing disruption caused by new technologies and deregulation. So a lot of what we talked about yesterday, a lot of what the general counsel talked about, the managing partner of Pinheiro said, I don't know what this firm is going to look like in 10 or 20 years because of the introduction of artificial intelligence, machine learning, predictive analytics, new players who are coming into the ecosystem. We have a whole separate project on disruptive innovation in the market for legal services, and every place around the world is thinking about this. And Oscar, I know here at FGV, people are thinking about what that's going to mean here in Brazil. You got now a whole bunch of new kinds of legal service providers. They're called, kind of in the terminology, alternative service providers. And there are a bunch of different kinds. So Axiom is a venture capital based kind of gig economy work for lawyers. In other words, it's like Uber for a lawyer. You can sign up, you can work, you get staffed on projects, they scope the projects out, you work on the project till it's done, and then you can, quote, go on the beach, which means you can say, I don't want another project for 3 months or 6 months, right? Just think of the gig, and this is only one of many models of the gig economy coming to legal services. Or you've got Ravel Law, which is a company that just got acquired by Lexis. At Harvard, some of you may know this, we have something we used to call the Free the Law Project. I don't think they call it that anymore. But basically, Harvard is digitizing all of its case law, and then it's going to give it away for free. But they've partnered with this company called Ravel, which is a kind of legal project management, process management firm, which is also into data analytics and machine learning. And then the whole slew of AI providers like IBM Watson or Cura Systems, all of whom are entering the market for legal services. And finally, you know, these people we still foolishly call accounting firms. You know, accounting's been a lost leader for 20 years, okay? And they tried to enter the legal services market, as many may remember, 20 years ago. And then, you know, all the accounting scandals and the collapse of Enron and WorldCom. And we thought we drove a stake through their heart, and we kicked them off the island, and we banished them to the Middle Kingdom. And then we forgot about them, and we thought they were gone. But au contraire, as everybody around the world, except in the US, knows, the Big Four have now re-entered the market for legal services in a much bigger and more sophisticated way than they did before. Before, they just tried to look like law firms, only bigger. I mean, they didn't quite call themselves King and Wood, but they called themselves Anderson Legal Services or Landwell, and they tried basically to just mimic the structure of law firms. They don't want to be law firms anymore. You know what they call themselves now? Globally integrated solution providers. And guess what's a big part of a globally integrated solution? Yeah, your students' jobs. Or, you know, or maybe your students are now going to go work for them, right? And they are exploding all over the world, selling solutions that integrate technology, process management, project management, tax, sophisticated advisory, and of course, law and legal services. And they are going to be very potent players. And this is being pushed in many places by the state and not just in China. So that bastion of free market, common law, Brexiteering, okay, the UK. The UK Legal Services Act, which deregulated much of legal services in the UK to the point where the solicitors and barristers, although they have nominal regulators who are professional, the ultimate regulatory authority is the Legal Services Authority, which is run not by a lawyer, but by a competition policy expert, okay? Who has many different views about where the boundary between different kinds of legal services and who should be able to provide them should lie than the old barristers or solicitors who used to run it, right? And that has created a huge market for alternative legal service providers now who are based in the UK. So all four of the Big Four have now been granted alternative service, ASP, basically licenses to deliver legal services, multidisciplinary legal services in the UK, okay? I just came back from Singapore. I was in Singapore the last week in August, right before my school year started. The Singapore government has something called the Future of Law, what's it called? Future of Law Initiative Program? Yes, Future of Law Initiative Program, or FLIP. They're almost as good as acronyms as Dave Trubek. And here's what they're doing. They're putting in millions of dollars, tens of millions of dollars, to attract legal technology companies to come to Singapore, both big tech companies like Microsoft, which are getting into the legal tech world, and people like Kira Systems and Watson and others who are already in the legal tech world. They are giving grants to law firms to locate their legal technology hub. So Clifford Chance got a grant from the Singapore government to make, can you believe this? I couldn't believe this. Got a grant from the government to make Singapore the legal technology hub for Asia, and basically the biggest one outside of London for their legal tech. And Clifford Chance is doing all sorts of stuff in the legal tech world. They're working with law schools. They're trying to redesign law school curriculums. They're working with solo and small firm practitioners to try to help them to incorporate technology into their practice. What are they doing? Why are they doing this? Well, Singapore, you know, it's a little dot. Actually, they call themselves the dot, okay? You know, and basically, they have survived and prospered by making themselves first a financial center, which is becoming increasingly important as people get worried about China's influence and Hong Kong increasingly under Chinese control. They want to now compete with Dubai. Second, they're a dispute resolution center. So they've been pushing the Singapore arbitration as an arbitration center, which now competes with big, you know, London and Paris and again, Dubai and Hong Kong. They're deregulating their legal profession, so they've now have allowed foreign law firms to come in. And they see this, and legal technology is the last piece, and they see this as a way to, as law as a gateway to attract other kinds of investment into Singapore. See the idea? It's a little bit like China thought, only now being done at a very highly professional level. I mean, those of you who've been to Singapore, if you think China is China Inc., I mean, Singapore is nothing but Singapore Inc. And the government is extremely professionalized and thorough in the way in which they think these things through. All right, this leads to two big questions. One, what's going to happen in a world of growing protectionism where services, in particular lucrative professional services, constitute an ever bigger share of global trade? Are we going to see countries like the US, which have not had a lot of state intervention into the legal market, beginning to push legal services as an important entree into US interests in global trade, right? In Australia, when the Australia foreign minister travels abroad, the heads of the corporate law firms go with him, or her, because the point is they see corporate legal services as a huge part of the Australian market. Are we going to start to see that in the US? Second, what is going to happen in an increasingly boundaryless and technologically led world, okay, in which you've got now global regulation, things like the General Agreement on Trade and Services, which has been trying to cover law and legal services for some time, right? You've got global professional networks like the IBA, which is increasingly powerful and important around the world. How is that going to reshape macro level relations between the state, the profession, and the market? I say in the US because that's where I'm from, but really around the world. So here's the last slide, okay? You thought the gears were complicated enough, all right? Here we go. We've got disruption now because we've got at the macro level, the state is increasingly pushing the gearing, and you've got these new players who are playing a more and more important role inside the legal system, and it's pushing back this way as well as this way, right? Because the changes in the market may encourage more state intervention and eventually either more global regulation or more global interaction. If that looks complicated, it is. and I actually have no idea how this is going to work. So that's why we have a bunch of really smart FGV graduate students. You have been incredibly patient and sat through what has been a very long presentation, but I hope it gives you a sense. I'll just close by saying kind of 3 quick things. One, why studying the legal profession is important. You know, because the legal profession is becoming more and more important around the world. Our entry into it is the corporate legal sector, but there certainly are others one might study, but why it's important, why it has to be studied second in a global context, because it's increasingly global. And the last part, it's never stable or set. It's constantly changing. And all we've tried to do in the book is to document one important change, right? The kind of global shift until, roughly speaking now or a few years ago. But that's just kind of the beginning. And now what we need to do is think how all of these complicated things are going to play themselves out. And with that, I think we'll stop. Thank you very much. Thank you. Thank you. All right, have we exhausted everybody? Garces.
Thank you, all of you. Just to say that the book is here.
Yes,
Right. Well, yeah, I'll just pass it around if you want to have a look at, provided you give it back to us, or pay $150, right? No, I'm kidding.
It's ridiculously expensive. I'm sorry. There's nothing we can do about it. Cambridge sets the price. But we're pushing very hard to have it out in paperback, hopefully by the spring, right, Brian? We just have to sell a few more copies to law firms and libraries and people who can afford to buy these things. But we hope that it'll be something that'll be available because, listen, many of your colleagues have written important chapters. And again, it's a starting point for then whatever the project you might want to carry forward might be.
Yeah, that's again why I wanted to emphasize. The book there is, of course, is a snapshot of one moment in global economy and the legal profession, but we need people that want to take this forward and continue the work and even criticize what we've done and find our flaws. So I think that as you go through the book, maybe you find project ideas that you might want to get involved in, apart from your own projects. Nowadays I give you Professor Mario Shapiro. No, it's okay. It's been long, but I think we can take a couple questions.
Yeah, we could talk about this all day, as you can see. And it doesn't have to be about anything specific. It could just be a question you have about the legal profession in the U.S. and other countries and what might be relevant to your own research. Yeah, please, thank you. And then over here too.
Hello. I have a question about...
Do you mind saying, you probably all know each other, but I'd love to get to know you better. Okay. So you could say maybe your name and are you a graduate student here? And yeah.
My name is Bruno. I'm a mastering student, and I work at a regulatory office in a corporation.
Oh, okay.
But my question is about the strength that a corporate lawyer or in-house department has over the state officials and the state personnel and expertise that with higher and higher qualifications going to the private markets and the public market becoming less and less powerful, less and less expert in the matters. So we have really a change in balance, and regulation becomes a little fuzzy because when the corporations know more than the state, you have an issue there. And this movement aggravates the problem. I would like to know your opinion on the matter.
So I think it's a really important point, and I'll just say something quickly, but Dave, maybe your telecom study might be of interest here. I mean, so the phenomenon, you could go under many names, but you might call it regulatory capture. I mean, the issue of what happens when the expertise resides primarily in the private sector, and the private sector is exerting more and more influence over the regulatory process. So I'll just give you an example from India to show you why what you're saying is very important, and then maybe Dave, you could talk more about this in the Brazilian context. But so I was having lunch with the general counsel of one of India's top conglomerates. You know, the Indian, there are a lot of these kind of family-owned conglomerates, the Tatas, the Mahindras, the Ambanis, who control huge amounts of the economy. So partly why the in-house council revolution has been different in India is because many of the companies are controlled by families, and the in-house counsel is as much a kind of consigliere, if you know what I mean, a kind of, you know, confidant of the, maybe even a family member, and certainly a member of the same, you know, sort of communal group, right, from the same part of the country, the same, oftentimes either religion or communal group. Okay. He said to me, you know, I used to spend 40% of my time in Mumbai, commercial center of India, 40% of my time in London and New York, because we have substantial business interests around the world, and the lawyers were all in London and New York, and then the other 20% sprinkled around, some in Delhi, some in other places in India. He said, now I spend 40% of my time in Mumbai and 40% of my time in Delhi. What's he doing? I'm interacting with officials about regulatory change. Now, it cannot be called lobbying because lobbying is illegal in India, like specifically illegal. But we heard many stories during the course of this work about how the new corporate reform or the new securities law or the new trade law, before it went to Parliament, was passed by either this general counsel or the managing partner of one of the top law firms. So yes, they are a major force. Again, it's another reason why studying these corporate lawyers and their increasing influence and power is important for lots and lots of things. But Dave, do you want to?
No, I think that, you know, we could tell a Brazilian story, some similar stories, and certainly the story about telecoms, which is reported in the book, is a story about how the lawyers basically managed to curb regulatory initiatives and help shape the form in which these initiatives took. So I think this changing balance it's a Brazilian phenomenon as well.
Yeah, here, and then another microphone over here for this gentleman.
Okay.
Well, Mario?
Okay, thank you for your presentation. And in your narrative, you guys overlaps the political economy and the development of the legal profession. And regarding the future, my question is about the in this overlap, the relationship between the development of the legal profession in these countries, in particular in Asia or China and Singapore, or even in Brazil, and the future of the democracy. Because on the one hand, your description is about the development of the legal profession in a global standard, in a very complex way, which somehow could be related to the development or the fostering of development or democracy in these countries. As you know, my connection here is that the more developed is the legal profession, the more developed tend to be the democracy, because democracy is related to the rule of law and the lawyers and so on and so forth. But on the other hand, some authors are now suggesting that democracy can fail, or the recent book by Levitsky is one of the good example of that. And more than this, your model is telling us that the state, and in particular the developmental state, is one of the main push driver of this diffusion of the legal profession in the world. So what is the connection that you see between the future of democracy and the future of the legal profession in this world?
Intimate. Well, I think that that's one of the great questions. I think that there's a general sense that the legal profession prospers when there is, to some degree, a rule of law, or a rule of law that you can get around, but it takes skill to get around it. So the growth of a legal culture and the growth of the legal profession go together. And so the question is, what is the relationship between the growth of a legal culture and democracy? And I think the answer is complex and not necessarily, it's not necessary to have a strong legal culture and a vibrant democracy. You can say that a strong legal culture will be helpful for a vibrant democracy, but you can have a strong legal culture in a very truncated democracy. So I don't think that you could say the best way to build a democracy is to build a strong legal culture. A strong legal culture is part of maintaining a strong democracy, but it's not the primary pillar on which that would rest.
I think that's right, and I'll just say just two more quick things. It's just another spin of China is different, okay? Because China's actually trying to build a legal culture, but they don't want that legal culture to undermine the democracy, and so they constantly to create. Yes, sorry, that's what I meant. Yes, they don't have any democracy, and as we know, this is partly why Singapore. You know, under Xi Jinping, it's getting worse, right? And every lawyer I know tells me that. And I'm not just talking human rights lawyers. Every corporate lawyer I know says it's a much tighter, there's more control. One of the things the government is doing, for example, is, this is why Dave said we're still investigating kind of the party status idea. So every organization of any size in China has to have a Communist Party organization inside it, including law firms. But in the old days meaning 10 years ago, nobody really took those apparatuses very seriously. Apparently, there's been a move to reinvigorate them. Now, I guess I'll say this because we're in a law school and, I don't know, I'm a hopeful, optimistic guy. I think partly what happens is, and what's happening as we see in China is, if you create a legal culture, there are aspects of that culture that are going to rub against the idea that that culture should be in service of a fundamentally undemocratic and autocratic regime. And we see that in lots of places, you know, when the founding fathers of my Constitution, notwithstanding the play Hamilton, which you may have seen, in which they were all people of color, they were none people of color. And if they thought that when they wrote all men are created equal, that it was going to mean that that the sons and daughters of slaves were going to be able to vote and become president of the United States or whatever, they would never have probably written those words, okay? But there's a way in which you write those words and you create the culture, and then it provides a mechanism. There's no guarantee. And people in China, so now there are all these lawyers, okay? And these lawyers like to go to the International Bar Association meetings. And when they go to the IBA meetings, as Osvaldo knows, people are going to say to them, well, what's your pro bono policy? And what's your gender equity policy? And what's your corporate social responsibility policy? And you can't say, well, we don't have those in China, okay? Because then you're not a real law firm. And then you're not a real player in the global legal profession. So it's not to say there's any guarantee, but there is this tension. And so if you go back to Desolé and Garth, you know, who wrote a long time ago about this kind of strange relationship between the globalizing corporate sector and the globalizing human rights sector, both of whom have some stake in some idea of the rule of law. But what that means and how it plays out, I think, is exactly up for grabs, and it's why law schools and every organization that influences lawyers has to make sure that some public culture idea of a law as a public profession dedicated to a set of public ideals that, at least roughly speaking, are consistent with the rule of law has to be a part of this kind of new advanced corporate legal education. Otherwise, it's a disaster. Yeah, please.
Thank you. My name is Tariq. I'm a student member of the first class of Professional Master. My final paper was about the globalization on legal services, pardon. And I could identify some phases. One was the opening, when we create the Council of Lawyers of Mercosul, created by Brazil, Argentina, Paraguay, and Uruguay to think about legal education, legal service regulation. So then we stop it. We close our market. So I would like to question if there is any dialogue with Brazilian bar about these challenges, research in common, and second, understand more about the Singapore legal technology.
So I'll just say something quicker than Dave. So I think I have the distinction of being either the only, I'm not sure I'm the oldest, I'm not the oldest living client of Pinheiro Neto. I can't get anywhere close to that. But I might be one of the only U.S. academics, legal academics, to actually address to do a keynote address at OAB's big biannual convention. I did it actually in Rio a couple of years ago about these issues. I think, you know, as within any big complex organization like OAB, there are forces that want to push for what sometimes is called greater liberalization, but there are also forces that resist. I think the really interesting question is going to be, how long is the Brazilian state going to allow OAB to control the development of the legal sector? I think in India, although I thought time was up when the Modi government came in, it turns out time wasn't up because they have the Supreme Court on their side. But there's substantial push against professional control. And I think if you see, so this leads to the question about Singapore. The more these new models become extantiated around the world. In other words, the more you get these new legal service providers and these multidisciplinary firms and these new capital infusions inside law firms, the harder it's going to be to draw the borders, because the more easily it will be to work around them. And so I'll just speak about the United States. I think there's already growing pressure in the US to try to allow for things like multidisciplinary practice, which are right now prohibited. So I can't give you a timetable, but I can say that the more the global gear cranks, the harder it'll be for any particular jurisdiction to deviate significantly from things that are permitted in other parts of an increasingly connected global ecosystem. Dave?
Couldn't have said it better myself.
Okay. Any other thoughts, comments, questions? This has been a long day. You guys have been fantastic. I'll just say this. If anybody thinks of anything, or if you have a question about how your research connects with ours, please let us know. Drop us a line, talk to Luciana or Garces or some of the others who have been so influential in this work, because we feel a very special attachment to this law school and to the graduate students in particular, because really, you're the future. I don't really know the answers to these questions. We can put the questions up here, but we don't know the answers. We are hoping that you will begin to help us to better understand how all of these phenomenon work. And we can't wait to see what you come up with. So, I think we're done. Thank you very, very much. Muito obrigado. Obrigado.